Hi everyone, welcome back to another episode of Let's Talk Legal with Karimi Chege. My name is Ashley Karimi Chege, an advocate of the High Court of Kenya and your go-to employment expert. This is Season 1, Episode 9 of Employment Law Unlocked, a special issue that arose out of Episode 8 of Employment Law Unlocked, where we're talking about overtime. So if you've not watched Episode 8, I highly recommend that you stop this video right here and proceed to watch Episode 8 so that you can understand how we got here. However, if you've already watched Episode 8, I know you remember where we're talking about children. And we indicated that the law provides that children under the age of 16 years should not work for more than 6 hours in a day. And I got so many questions of people asking whether children can be employed. And that is the exact question we want to answer in this episode. So what are the objectives of today's episode? 1 is to define who a child employee is. 2 is to establish the minimum age of a child employee under law. 3 is to indicate the tasks and activities that can be done by a child employee under law. And 4 is to outline the prohibited acts or tasks that cannot be done by children employee under law. So let's get straight into the episode. The law provides under Rule 23 of the Employment General Rules that a child employee is defined as an employee who is yet to attain the age of 18 years. Further, under Section 56(1) of the Employment Act, it makes it an offense for an employer to employ a child of less than 13 years. That means a child employee is anyone between the ages of 13 years to 18 years. However, as we go along this episode, you will notice that their law places more reliance on children between the ages of 13 years to 16 years. This is due to the fact that such children are still undertaking their basic education and they are more prone to exploitation of labor as compared to those who have already attained the age of 18 years. Now, for children who are between the ages of 13 to 16 years, the law provides that such children can be employed to do light work or as indentured learners or apprentices. Now, in regards to children employment, apprenticeship or indentured learner means the child will be placed under someone who will train them to perfect a certain skill in a certain trade. The law also provides under the 5th schedule of the Employment General Rules the tasks that are indicated as light work, and we will get to that in a few. Now, the reason as to why the law provides a particular amount of work or a specific amount of work that a child in employment can undertake is because of the provisions of Article 53 of the Constitution of Kenya. Under Article 53 of the Constitution of Kenya, a child is protected from exploitative labor, and the said provision also indicates that the best interest of the child is to be put paramount in all decisions that pertain to the child. Therefore, in regards to children, it is more paramount that whatever task that they are undertaking in their employment, the same should not interfere with their health, with their development, and with their education. If the said tasks or activities interfere with those 3 things, then those tasks will not be in the best interest of the child. Now let us go back to what constitutes light work. Under the 5th schedule of the Employment General Rules, it provides a list of activities that are considered as light work under law. The list includes work performed at school as part of the school curriculum for the benefit of the child, agricultural or horticultural work not exceeding 2 hours, delivery of non-bulk newspapers or printed materials, shop work including shelf stacking. So if the work of the child is to put items in the shelves, that is considered light work. Domestic hairdressing, where the child is taught how to plait and how to keep the hair neat, just for domestic purposes and not for commercial use. Light office work, it can also be done through apprenticeship or as an indentured learner. Car washing by hand in private residential settings. Kindly note this point, they have indicated washing of the car through hand and not complicated machines. And also for residential purposes, where in a residential area, the cars that are coming into that residential area are limited, and that means that the cars that the child employee will be subjected to will be also limited, ensuring that they are not overwhelmed with work. Work in a cafe or restaurant, provided the nature of work is restricted to waiting on tables. So if a child is working in a cafe or a restaurant, they are restricted to waiting on tables and not to work in the bar or to entertain guests. Now we have talked about what constitutes light work and the kind of work that the law allows child employees to undertake in. So what are the prohibited acts or activities that the law does not allow children to undertake in? Section 53 of the Employment Act makes it an offense for anyone to subject a child to activities that constitute the worst form of child labor. Under paragraph 24, in the second schedule of the Employment General Rules, it outlines what constitutes activities that form part of the worst form of child labor. They include any acts of slavery or child trafficking, forced labor, prostitution, drug trafficking, or any activity that may affect the health of the child. Further, under the fourth schedule of the Employment General Rules, it provides an extensive list of activities that are deemed to be harmful to the health, safety, and moral of children. The same is provided for herein, but just in brief, we can outline a few. In the agricultural sector, children are prohibited from working with machinery, working with chemicals, moving heavy loads of animal feeds, and ferrying heavy farm produce. Further, in the building and construction work, children are prohibited from earth digging, carrying heavy loads, breaking stones or rocks, shoveling sand, ballast, cement, or soil. They are also prohibited from metalwork, welding, ascending to high places, working with ladders, working in confined spaces, and working with risks of structural collapse. Under urban informal sector and street families, children are prohibited from begging, and they are prohibited from the use of toddlers to ask for alms. In the tourism sector, children are prohibited to act as tour guides, to provide entertainment performances to tourists, and in the hospitality service. In service work, children are prohibited from commercial modeling and commercial hairdressing. Now, in regards to the formal nature of employment contracts entered into between employers and children employees, the law prohibits children from executing written contracts of employment and also prohibits parents or guardians from executing written contracts on behalf of their children. If you want to procure the services of a child employee, the same should be done by verbal contract. Further, under Section 61 of the Employment Act, it mandates that the employer is the party responsible for maintaining a register of the information of a child employee, that is, the age of the child employee, the date of birth of the child employee, the date when they arrived at the company, and the date when they will exit, and any other information that may be relevant for the employer. Further, this information should be maintained in line with the provisions of the Data Protection Act. Now, in the event that you are aware of a child who is being subjected to the worst form of child labor, you are at liberty to make a complaint at the police station. The police will then investigate the complaint and proceed to take appropriate action. Further, in regards to the people who are perpetrating the worst form of child labor upon children, the law indicates that the same is an offense, and the perpetrators, if found culpable, will be liable to a fine not exceeding 200,000 shillings or to imprisonment of a term not exceeding 12 months or to both. That marks the end of episode 9 of Employment Law Unlocked. But stick around for episode 10, where we continue to talk about the benefits under the Employment Act. You do not want to miss this. Thank you so much for watching, and thank you so much for the interaction that we have seen in our episodes so far. We don't take it for granted, and if you have any further questions in regards to any of the episodes that we have already put on YouTube, you are free to reach out to us through the information in the description box below. Till next time, remember, information is power, legal knowledge is freedom.